That's fine. And you are correct. What normally happens is the club would activate the disciplinary provisions, which is usually one of the appendices to the contract, and punish the player accordingly, maybe by imposing a miserly fine that will take care of the situation, or maybe a warning. But just thinking aloud, I think it is also important so that you don't violate, or you don't appear to be violating the person's rights to fair hearing. Usually what a counsel who is representing the player would insist on when you put a morality clause, because whether you like it or not, it's a very wide clause that can attract a lot of things. The other day, we heard about the Ajax goalkeeper, Andre Onana, failing a doping test. So if there's, I would imagine there's a morality clause in the contract. Otherwise, that would be maybe an oversight on the part of the club's lawyers. But if there is a morality clause in the contract that empowers the club to probably suspend the player, suspend payment of salary to the player, pending the determination of that particular charge, because it's a doping charge, it's going to go through the doping commission, and then he will most likely appeal, or any of the parties who loses most likely appeal, and it will go to CAS. So we are looking at a window of maybe 12 to 18 months for there to be a final determination of that particular issue. So would it be right for the club to automatically invoke that particular provision and say, okay, you know what, we are suspending your salary, or even ultimately terminate the contract? So it is advisable for lawyers who are representing the player to insist that such issues, when there appears to be a violation of a morality clause in a contract, for an independent third party to be appointed immediately and saddled with the responsibility of probably determining the culpability of the player before a final decision is taken. Because taking that decision without involving the player might give rise to some certain loopholes, especially when the matter goes on appeal. But that is just by the way. Now, let us quickly delve into the world of image rights. Image rights clause has become very important because due to commercial expediency and advancement in technology, it's now advisable for parties to ensure that there's a separate image rights contract, especially for the very iconic athletes who have made a name, who have a very big persona that requires the club to properly identify the areas or address the potential areas of conflict. Image rights, as we know, is usually not recognized by any statute, especially in countries like the UK and Nigeria. We have our legal traditions from the common law, English Anglo-Saxon tradition. So we usually don't have a statutory protection for image rights. However, what you normally see is the application of certain common law principles, like the doctrine of passing off. However, in places like France, you have what is called personality rights. In the United States, you have what is called privacy rights. So, and the US, most especially, it was in the case of Elan Laboratories Limited and the Top Chewing Gum Company Limited, where the image rights of baseball players was established for the very first time. So what are image rights? Essentially, when you are talking about image rights, you are not speaking in the narrow sense of a likeness. You are speaking in the wide sense of a persona. And the commercial exploitation, which is usually the issue. Mr. A, who is a player in Club B, comes up and sees his image flying around, maybe a beverage brand, puts his pictures all over their products, selling it to people, and they say, oh, this person is also using this product. So that is essentially what an image right is. The player comes up and says, oh, you didn't obtain my permission to use my image. So you are misrepresenting me to your consumers. So these are usually the issues. Now, at the outset of a player's professional contract, his image rights belongs exclusively to him. However, there comes a certain level when the player gets to become signed to a big club, where he will now automatically assign some of these rights to his club. So there are three broad categories of licensees who usually exploit a player's image. You have his club, you have the national association, and then you have his commercial sponsors. Now, the extent of conflict can be very jarring for both the club and the player, especially when you don't need some of the disputes in the board. A typical example is a contract where usually there's a standard contract like you have in the Nigerian Professional Football League. You also have in the FA Premier League in England. That professional contract has the standard clauses there. So in the UK, most especially, you have clause 4. Clause 4 deals extensively with image rights and how it can be exploited by the clubs. Now, the teething question has always been who should be in control of image rights. Clause 4 of the FAPL standard contracts is deliberately silent on who owns the image rights. However, what the drafters of the regulations in England have done is to put in a mechanism that allows the club to use the image rights or exploit the image rights of their players. However, there's a caveat that says that the player's image shall not be used beyond the average use that the club has put with regards to the other players' images. In simple terms, it simply means that if a club is exploiting a player's image, for example, picture, his number, jersey number, his initials or whatever, the club must not be seen to be using it over and above every other images of the other players. That is why it is very, very common to see a commercial or promotional advertisement showing maybe 3 players of a club huddled together taking a picture. It doesn't single one person out. And this was precisely what happened in the case of Mohamed Salah and Egypt Football Association. The Egyptian FA president had called Mohamed Salah in 2017 to say, oh, our commercial sponsors intend to exploit your images. Now, usually what the players do, what most of the established players do is to, and that is for tax purposes, what most of them do is to establish a company that they assign their image rights to. So if there's going to be any commercial exploitation of their image rights, you will have to go through the company. Now, Mohamed Salah has MSCC. MSCC is a company that manages his image rights. And the Egyptian Football Association president called him and said, oh, our commercial sponsors intend to exploit your image and we need your consent. Mohamed Salah referred him to his company, naturally. So Presentation is a company linked to Egyptian Air. So Egyptian Air is actually the exclusive sponsors of the Egypt Football Association, the Egyptian Football Association. So Presentation Limited called MSC and demanded for Mohamed Salah's photographs. They said, no, what do you want his photographs for? So they were basically at the point of, okay, please, you need to tell me what you need the images for before I can release them to you. Lo and behold, Presentation ran off to the parent company, Egypt Air, and beamed images of Mohamed Salah in most of their advertisements. Now, the contention of Mohamed Salah's entourage was that Mohamed Salah's image, even though the Egyptian FA had selected Mohamed Salah and about 2 other players for that particular promotion, Mohamed Salah's image was subjected to a use over and above the other 2 guys. So it was a debate as to, we didn't give you the license to exploit his image. They were at the point of going to court when they settled amicably. Now, another case where the extent of this commercial exploitation has become a little bit interesting is the case of Rihanna and Topshop. Topshop Limited is a subsidiary of Arcadia Group, who is a retail fashion outlet. Now, Topshop had used Rihanna's image on a branded T-shirt promoting their products. Rihanna saw this. Interestingly, the facts arose in the UK because the earlier decision in Michael Douglas and OK Magazine, Hello Magazine, where the court held that when an image of an athlete or a celebrity is used, probably what usually happens is that you have a photographer who takes the image and sells it to another company. So in intellectual property, intellectual law, what you have, the owner of that particular photograph is the photographer and not the person who embodies that particular image. So that was the principle in Michael Douglas, because Michael Douglas had a lavish wedding in Venice, in Italy, and he kept all the celebrations top secrets, strictly on invitation, and signed a deal with OK Magazine. OK Magazine, one of the biggest magazine outlets in the UK. OK Magazine paid $1 million for all the photographs used at the wedding. So Hello Magazine was able to smuggle in a photographer into the wedding who took photographs of Michael Douglas and his wife, Catherine Zeta-Jones, and sold it to Hello Magazine. Hello Magazine published the photographs. Michael Douglas sued Hello Magazine for violating his privacy. The action failed because the court took the view that, well, that the intellectual property rights don't belong to Michael Douglas and his wife. But in Rihanna and Topshop Limited, the court took the opposite view to the effect that, what Topshop did constituted a misrepresentation to the extent that it gives the impression that Rihanna not only gave them license to use her image, but that she has also endorsed the product. So where does this leave the clubs and the players? Usually you have conflict of interest. The club is usually concerned about issues about conflict of interest because under the FA rules, a player must not enter into a personal endorsement that conflicts with his club's competitor. Let me put it in perspective. If the club is being supported by Coca-Cola, a player should on no account enter into a personal endorsement with Pepsi. That would constitute conflict of interest. So that particular clause actually obliges the club to not only exploit the image of a player, but restrict the player to his own brands. Now, what most clubs have done in the UK is to create an ingenious way of circumventing most of these hurdles. I'll give you an example. Zlatan Ibrahimovic moved to Manchester United in 2017. At the time Zlatan Ibrahimovic joined Manchester United, he was already contracted to Volvo, one of the biggest Swiss auto manufacturers. Now, Chevrolet, on the other hand, is an American auto dealer who are the major sponsors of Manchester United. So as at the time Zlatan came into Manchester United, because the rule then is that all the players will be driving the branded vehicles of Chevrolet. So as at the time Zlatan came in, Zlatan never drove Chevrolet one day to training. Zlatan was always driving his Volvo because he had an existing endorsement with Volvo. So that is because of who Zlatan is. What happens to the unknown player in the Nigerian Professional Premier League who doesn't know some of these rights? So thankfully, clause 4 of the English FAPL rules actually allows the players and the manager and the club to derogate from that clause. What it simply means is that you can create a separate image rights agreement. So when you create a separate image rights agreement, it can allow for, even for instances where there seems to be a conflict in the use of a brand who is a direct competitor of your club's brand. So that is it for image rights. So now there are certain safeguards that clubs have now come out to use with regards to checkmating the use of their image rights, one of which is morals clause. The morals clause simply stipulates that when the player is involved in obnoxious conduct, the club can terminate his contracts, suspend or terminate further payment of salaries. So I think I have not exhausted what I want to say, but this is the much I can do now that time can allow. So that is it for image rights. So I don't know whether there are any comments, questions. Otherwise, I will be happy to take the last words from the team. Starting from ID.
Thank you so much, sir. Of course, it was a very robust session. I thoroughly enjoyed the engagement and the conversation. And I am of the opinion that policymakers would listen to this and see how they can strategize to move our football forward using the instrument of the law. Thank you to everyone and to our various listeners. Thank you.
All right, thank you. Doing?
Thank you so much. Thank you so much for this session. I mean, I'm glad to be back speaking again, and I look forward to another session. I just want to say something very quickly on the
fact that... We have very limited time.
Okay. Okay, it's just about the fact that the photographer owns the image rights too. So, but I guess maybe we'll just address it in subsequent.
Definitely, we will.
All right. Thank you, everyone. Thank you very much.
Yes. DG.
All right, thank you very much. I'm really glad that we are back this year and we are back and better. So I'm looking forward to another interesting session with everyone. Thank you. See you next time.
As always, I'm always very happy to be a part of this exercise. We learned so much from it. I want to thank everyone that has spoken. It was very, very informative. I wanted to actually ask a question, but because of time, maybe we could just leave that for another time. But yeah, thank you, everyone.
All right, thank you. So, gentlemen, this is where we drop anchor on today's show. We'll be back next week with another bumper edition of Sports Law Unscripted. For now, it is bye-bye now from myself and the team. Thank you, and have a wonderful evening.